Hello, my name is Stuart Richland. Welcome to our website and welcome to my office, 420LawOffice.com. I've had the pleasure of being an attorney here in Southern California for about 25 years and the honor of representing thousands of patients and hundreds of medical marijuana collectives, focusing on the rights of medical marijuana patients and collectives for about 6 years. I've been proud to have been a victorious plaintiff in the medical marijuana case that we had against the city of Los Angeles during the early stages, in which we got a preliminary injunction against the city's original ordinance, and we actually forced the city through the court system to rewrite a more equitable ordinance. That ordinance is, of course, currently, as history has gone, subject to revision because of a recent court case. So at the current time, as Mr. Huizar stated, in the city of Los Angeles, there is no law regarding medical marijuana that's enforceable. On the other hand, state law has plenty of law, and state law provides that patients may grow their own medicine, transport it, and use it, that patients may have caregivers, which are people who are close family members or other close people in their lives who care for their health, safety, or housing, which may provide for their medical marijuana under state law and have a perfectly good defense. And there are collectives and co-ops, which are groups of patients which may join together voluntarily to cultivate, transport, and distribute marijuana. Unfortunately, all of the above is totally contradicted by federal law, which states that there is no such thing as medical marijuana, it's just illegal marijuana, and that there are no defenses for the activities of growing or selling, distributing marijuana. So this is the confusing state we find ourselves in. I'm proud to say that it's been my specialty to unravel that for you, and I'll be happy to do that as soon as you activate us by giving me a call at 888-420-LAW-1 and make an appointment to come join me for a consultation. My initial consultation is $500. It takes about an hour, and it includes my 120-page book on the topic, which is constantly revised to enable you to really understand the situation of how medical marijuana law works and to make an intelligent decision about your activity. If you should then choose to desire a nonprofit collective, I have a little upsell, which is another book together with a corporate book that enables you to begin to put together the documents necessary to demonstrate a state defense in the area of medical marijuana. And so the whole enchilada around here is $1,500 for those services. With reference to litigation services or expert witness services, those are done on a case-by-case basis. Just give me a call and I'll be glad to estimate what kind of work is involved. Hey, please check out the site, look around, and you'll see that I have a radio show that I do. I have my law comic book that's constantly updated for you to read on the website, and my link to my YouTube videos as well. So poke around there on the site, get all that free information, and then give me a call when you're ready so that we can schedule an appointment and get the book in your hands and get the knowledge in your mind. All right, take good care. Thanks for visiting. And here's a recent testimony of Eric Holder with reference to medical marijuana and his continuing support for the Ogden Memorandum, making federal enforcement a low priority for those that are following state law.
The issues surrounding the regulation of medical marijuana. I wanted to first clarify that there's a memo dated October 19, 2009 from David Ogden. I'm sure you're familiar with that memo. The contents of that memo as advisory to the states is still in force. Is that correct? That is still a current memo?
Yes.
Okay, thank you. And one of the issues that was later clarified in a memo by James Cole is what we're talking about when we're talking about caregivers, who your memo instructs should not be an enforcement priority. The Colorado Constitution in Article 14 happens to have a definition of caregiver. It's further refined in our Colorado statutes. And I wanted to see whether I can get your assurance that our definition of caregiver in our state's Constitution will be given some deference by the U.S. Attorney General's office.
I'm not familiar with the provision, but what we said in the memo we still intend, which is that given the limited resources that we have, and if there are states that have medical marijuana provisions, and if you take into account the Cole memo, if in fact people are not using the policy decision that we have made to use marijuana in a way that's not consistent with the state statute, we will not use our limited resources in that way. And so
Sure.
I don't know if, I assume that, I just don't know about that provision.
And again, yeah, in the case of Colorado, we do have definitions of some of the terms in your documents in our Constitution, and I would hope that the U.S. Attorney General for the state would look at that. Now, as you know, the Department of Justice recently announced a crackdown in California. Now, part of the issue there, it's my understanding, they did not have a functional state-level regulatory authority. Colorado does have an extensive state regulatory and licensing system for medical marijuana, and I'd like to ask whether our state regulation, our thoughtful state regulation passed with strong bipartisan majorities in both chambers of our legislature, provide any additional protection to Colorado from federal intervention.
Well, again, I'm not familiar with it, but I have to look at it. But again, our thought was that where a state has taken a position as it passed a law, and people are acting in conformity with the law, not abusing the law, but acting in conformity with it. And again, given our limited resources, that would not be an enforcement priority for the Justice Department.
Thank you. I'm grateful for that clarification. One of the issues that many of the legal, regulated medical marijuana shops and dispensaries in Colorado have brought to my attention is their inability to open bank accounts at most FDIC institutions. That makes the industry harder for the state to track, to tax, to regulate. And in fact makes it prone to robberies because it becomes a cash business as well. Is there any intention of the Department of Justice to prosecute bankers for doing business licensed and regulated medical marijuana providers in the states?
Again, I would think that consistent with the notion that how we use our limited resources, again, if the bankers, the people seeking to make the deposits, are acting in conformity with state law, that would not, again, be an enforcement priority for the Justice Department.
Thank you.